Good afternoon, guys. How are you? Good, strong, right? It's Wednesday afternoon, so your week's going well, right? You're looking forward to your exam next week. I know, with bated breath. Yes. Okay. So we are, as promised, you guys have a guest lecturer today. It is Chief of the Cherokee Nation, Chief Chuck Hoskins. And he is an alum of the University of Oklahoma. So you got that in common, which is awesome. And he is, like I said, the chief of the Cherokee Nation. The Cherokee Nation is the largest tribe in the United States. And he has been chief since 2019. Prior to that, he was Secretary of State for the Cherokee Nation. So without further ado, University of Oklahoma alum and chief of the Cherokee Nation, Chuck Hoskins.
All right, thank you very much. OCO, good to be with you today. We're going to talk about tribal government in the context of what you're studying in this class. And it's really important because tribes figure into not only the history of the country, but they figure into the Constitution, and they figure in a really unique ways to federal law. And they also figure into the relationship between the states and the federal government in the United States. And of course, we know from history there's been historical tensions in that area of the law, tensions that the Civil War for many reasons, and also today there's ongoing debate about federal state relations and roles. Tribes figure in to that equation, and tribes also, of course, existed before it was the United States. Exercise sovereignty, governing ourselves just fine before explorers who claimed to have discovered things found their way to the continent. We were here. And also in these times, contemporary times, the governments of Indian nations have a great impact on every one of you, certainly on me as chief and as a citizen of the Cherokee Nation. But in the state of Oklahoma, the tribes are all impacting your lives, I think, in very positive ways. And then more recently, because of some Supreme Court cases, the prominence of tribes in terms of jurisdiction, whether it's criminal jurisdiction, there's a case called McGirt, came up a few years ago, which reaffirmed the reservations of a number of tribes, including the Cherokee Nation. Those kind of cases will impact you and Oklahoma for a long time, for generations to come. And that's a reason that it's important to know about it. But it's really not possible to understand the full depth and breadth of the federal government and what it does without understanding how tribes play a role in that, pre-existed it, and are part of what you might think about as a family of governments in this country. You have the federal government, state governments, and the creatures of the state, like the counties, municipalities, and then the tribal nations that occupy a unique sphere. I'll talk about it from my best frame of reference, which is the Cherokee Nation, because I am Cherokee, chief of the Cherokee Nation. I know that history better than I know the history of other tribes, but it's a familiar story, and the law is essentially the same across the country. Anyone in here is a citizen of the Cherokee Nation? We have some Cherokee. What about other tribes? Other tribes. other tribal citizens. So the information I share is relevant and applicable to the other entities. I think about the Cherokee Nation, today, we occupy a reservation, 7,000 square miles in the Oklahoma, covers 14 counties, borders and takes into some of Tulsa, the rest of it largely rural part of northeast Oklahoma, it includes communities, parts of things like Muskogee, all of the land. I'm from Dunedin, the northeast part, and Tahlequah is our capital. But before we remove forcibly to that part of the country, which was before the state of Oklahoma, our homelands were in the southeastern part of the United States. We predated the United States. Our removal, and I'll talk about in a moment, was along with, hopefully know, people in the country should know about the Trail of Tears, of course, the removal of the Cherokee. People, other tribes, in fact, the history of tribes in the country, the history of dispossession, of suppression, of oppression, and that's the history that we ought to know. There's unfortunately a movement in the country that's prominent in the states, and we maybe ought to not teach those things, particularly in the public schools. Really, obviously, we've got to teach those things, the difficult chapters, and we got to learn from them, because it's not that long ago that Native Americans in this country weren't even citizens of the United States fully, just after the turn of the 20th century. Great deal of history that we ought to, I think, know this country. This is part of it. So the Cherokee Nation was existing before there was the United States, and European contact happened. A lot of tribes were decimated. Some of them smaller Indian nations, many tribes. People may have forgotten, flashed off the face of the earth for a variety of reasons: pressures, genocide, sickness, okay, with wars coming over, but a great deal of purposeful, intentional wiping out. Cherokee Nation wasn't wiped out. It's a large tribe. And one of the things we did that was really significant, and this is the part of history that I try to share with young Cherokees in particular, is as the pressure started to grow and the United States started imposing faith on tribal lands, even though we had treaties going back to the British Crown. We had treaties with the United States from the founding of the Republic. And those treaties are the supreme law of the land. In fact, I should have mentioned from the get-go, the United States Constitution, certainly studied to some extent in this class, has at least two articles in it that are really relevant to understanding tribes. One is Article 1, which is the Commerce Clause. That's the section that's really important for understanding how the federal government is able to operate a great deal of authority across the country, even though we're made up of 50 states. Because it regulates the commerce between the states, that's been interpreted broadly. There's also part of that clause, it's the Indian Commerce Clause. Congress regulates the affairs of the United States and Indian tribes, commerce with the tribes. That's been expanded or interpreted broadly. That's really important. The other is Article 6 of the Constitution. Treaties are the supreme law of the land. And that informs the legal system about what a treaty means and what its effect is. That includes Indian treaties. So the Cherokee Nation has a lot of treaties. But as the pressures were mounting and states like Georgia were imposed over tribal land, there was a real problem for the country, a problem for Georgia. You got all these Cherokees in your midst, and you've got a state. And if you're the governor of the state of Georgia, you say, that's our laws apply. If you're the Cherokee Nation, you say, we've been here before anyone ever heard of Georgia or anyone ever invented the United States. So with all due respect, it's relevant. So what did we do? We could have tried to go to war, I suppose, with the United States, and we were a fierce people. I don't know that would have ended well. The United States is becoming this emerging power in the world, and certainly in our world is power. What we did was really significant. And there are two things that happened, and they're related. One was someone who was an absolute genius, a revolutionary. I think the most important person in Cherokee history. He never served as chief. His name was Sequoyah. He invented the written Cherokee language. He invented a language that caused the Cherokee people, once we accepted it, but then a short period of time become literate, be able to talk to each other in writing, something we hadn't done before. And in translating that, talk to the world, and then hear back from the world about our struggle, about the oppression and the suppression, and what we were doing about it. So that was so important. It was the most powerful sword or shield that we ever wielded. Any time in our history was the pen. And the ability to write, communicate with each other. we leveraged that to do something, the second thing, really, because we changed the way we governed ourselves. We were a decentralized people. We tried the same pattern historically, but we did it earlier than others, I think, which is we went from being a decentralized people governing basically on the town level, united by culture, language, and history of time immemorial, to a centralized government that looked a lot like the United States. We started electing a principal chief. We had three branches of government: the judiciary, the legislative branch. We developed a stronger centralized government because we had to go toe to toe with a strong government, the United States and states like Georgia. We had to exercise our sovereignty in a way that the United States would understand, particularly in terms of government-to-government relationship. What does a treaty mean? Who is the country treating with? What should the state of Georgia do about a tribe that has this democracy based on the rule of law? So that's how we tried to stand our ground and avoid and resist what was coming, which was removal. One of the things that happened in our history that really was a tipping point was when they discovered gold in the hills of Georgia, where that was our tribal land. And if you're most people, see the gold in your land, you say, oh, Eureka. You're an Indian, and it's the 19th century. You don't say, oh, Eureka. You say, oh, something else, because you know that there's going to be a great deal of attention to your resources, and there was. So there was a lot of pressure brought to it. What did Georgia do? First thing Georgia did was ask the government of the United States, get rid of these Indians. You got to get rid of them. The United States, though, had a legal tradition that it would deal with Indian nations based on treaties. There was a level of respect. It wasn't just, holistically goodness, but that was the legal tradition. It was also very difficult for the United States to operate as a federal government if you had all these states dealing with these tribes in different ways. It's tough to manage them. The United States had an interest in doing it from the top down. So the United States Congress passed something called the Georgia Compact, which basically said, we'll get rid of these Indians as soon as we can. You can't get rid of them right now. We will treaty with them to get rid of them, move them across the map. They started to explore the rest of it, where they're already in this, by the way. Georgia wasn't real happy about this, but it was some progress. Georgia started to assert its laws onto the Cherokee Nation in a particularly purposeful way. They're really needless. They said, for example, if you're going to be a non-Indian living in the Cherokee Nation and working in the Cherokee Nation, you've got to have a license from the state of Georgia. And they passed another law saying that Cherokees could even be witnesses in their own criminal trials in the state of Georgia. That seems problematic under the American legal tradition, but that aside, this law that said if you were a non-Indian, you had to have a license is problematic because to get that license, you had to pledge allegiance to the state of Georgia. And you had to agree that the Cherokee Nation wasn't a nation within the authorities. A lot of people did this. We had some non-Indians in our midst. Some of them were missionaries, and they were missionaries who worked well. But one of them, Samuel Wooster. Samuel Wooster was one of the best friends the Cherokees ever had. One of the Cherokees. He went to jail and was willing to give up his liberty, violating that Georgia law for a principle. And the principle was he believed that the Cherokee Nation treated him well, was a sovereign Indian nation. So how did we test that? Did we go to war with the United States? We might have. It wouldn't have ended well. We went to court instead. We went to the United States courts. We took them to their own forum. And we challenged the idea that a state could reach into the Cherokee Nation and apply its laws, notwithstanding that, Oklahoma can't reach into Kansas and apply its laws. That principle we thought mattered. We thought the rule of law mattered. We thought an Indian nation that existed before there was the United States or state of Georgia mattered. That's an important principle, an important moment for the country. The President of the United States is Andrew Jackson, anti-Indian. The Chief Justice of the Supreme Court is John Marshall. John Marshall decides this case. We struck out the first time we went to the court. They said they didn't have jurisdiction on the particular case. But this case about Wooster, who was in jail, and said, you can't hold me in jail because these laws of Georgia should never have reached into the Cherokee Nation of God. Supreme Court agreed. The Supreme Court said that the Cherokee Nation was a sovereign nation. It predated the United States, and that's really important. That's a legal principle that sticks with us today. It's the reason that it matters whether you live in a state with Indian tribes. It's the reason that if you drive in northeast Oklahoma, you're subject to the laws of the Cherokee Nation. You could be subject to criminal penalty. It's still an emerging area of the law, but you might have a difference in how you're taxed, depending on who you are and where you go within the state of Oklahoma. A host of issues that are raised by this idea that Indian nations are a particular kind of sovereign that can exercise law and exclude law. And that debate's still going on today, right? Whether the United States or the state of Oklahoma can reach into the Cherokee Nation and regulate hunting and fishing, and regulate all sorts of activities, can impose criminal law when and where, and impose taxes. There's a case right now before the Oklahoma Supreme Court whether personal income taxes can be applied to a Cherokee citizen living and working in the Cherokee Nation. These are big issues, but it all stems from that case about 1831, Cherokee Wooster versus Georgia. So it's important to look at that case if you ever get a chance. It helps you understand what's going on in the country then and what's going on now. Well, in those days, the Supreme Court saying something didn't always mean a great deal. After the case, they would say Andrew Jackson said this, which is that John Marshall has made his decision and let's see him go enforce it. Even if he didn't say it, that was legitimate. And the governor of Georgia said you can go pound sand at the Supreme Court. We don't care. They ended up releasing Wooster, but it wasn't really because the Supreme Court said release him. They were sent federal marshals down. But the die was cast from the Supreme Court standpoint that we had sovereignty. But there's another principle of Indian law which is really important to know. So just had to know a few Article 1, Article 6, interstate commerce, Indian commerce, and then the second one, Article 6, treaty. The Congress and the courts have looked at that and they said that means the Congress has what we call plenary authority of the affairs of tribes. And we look at that and say, well, that's the government's interpretation, but if the federal government interprets it that way, that's a big deal. We can't just say, that's nice that you have that opinion. That opinion means something. And so what it means is that the Congress can look at just about any aspect of the relationship between the United States and tribes, and they can change it a great deal, and they have changed it a great deal. And think about this. I'm the elected chief of the Cherokee Nation, but my grandfather lived most of his life during a time when he couldn't even vote for the chief of the Cherokee Nation. Why? Because the government took that away. It said Cherokee Nation was a great democracy. We're going to suppress it almost out of existence. And they did that to most tribes during most of the time. Congress can do a lot. Congress, after that Supreme Court decision, at the behest of Andrew Jackson, passed the Indian Removal Act. Passed it narrowly, but passed it. We continued to try to resist, but Congress passed this act and said, we're not just going to try to remove the Indians, we're going to remove them. And we are going to get a treaty out of it. They came to the Cherokee Nation trying to get a treaty with my predecessor, John Ross. John Ross wouldn't sign it. And the majority of the Cherokee people, I mean the vast majority, said, we're not removing anywhere. This is where we live. This is where our ancestors lived. This is where we've lived dating back to the oldest oral history we have. We're not leaving. The United States is new, and Georgia was just invented. We're not going anywhere. But the United States, with all these pressures to get resources and exercise dominion, negotiated with a minority faction of the Cherokees who wanted removal. Now, these folks didn't want removal because they were bad. They wanted removal, the Cherokees, because they wanted to survive. And their view of how the Cherokees survived was sometimes you have to do a strategic retreat. Maybe removal is the way we survive. Maybe standing our ground is our last thing. That's the way they go. But the important point here is that the United States decided to be treaty not with the government that was sovereign and was recognized, but with this minority faction. Imagine today if the president tried to negotiate a treaty with Great Britain. The prime minister said no, and Parliament said no. And the president just found some Britons and said, we'll treaty with you. And that would be laughed out of the room. But that's what happened in this country in 1835. The Treaty of New Echota. As a result of that treaty and the Indian Removal Act, our people were rounded up in stockades. Now, this would be tragic if it happened. We had a government based on democracy, rule of law. We had a great economy, commercial enterprises, obviously illiterate people, because it's a place. more literate, by the way, than our Georgia neighbors. We're about 90% literate. Doesn't matter whether we were so-called sophisticated society or not. This should not happen to people in this continent, but we were rounded up in stockades, marched forcibly across the country. We lost a quarter of our population. 4,000 men, women, children, grandmas, grandpas, and they wiped off the face of the earth. My great-grandfather, or great-grandfather, was a baby and thankfully survived, or I wouldn't be here. But more than he survived, we survived as a people. We rebuilt. Don't have time for it here, but every chance I get to talk to a young Cherokee, I don't talk as much about removal. Trailer here is not real important. Talk about what happened next. We rebuilt against all odds in what later becomes Oklahoma. It was purposeful, those treaties and the removal to destroy the Cherokee, but we were disciplined. We were tough. We had great determination and we survived. That's another reason that we're still here today. But insofar as federal Indian law goes, the importance here is that the United States imposed a treaty. It was treated to devolve the land. In fact, subsequent treaties that they signed with the Cherokee Nation effectively brought that treaty forward. So yes, that treaty was imposed under questionable circumstances at best. We continue to sign treaties with the United States, including the Treaty of 1866. And so we have this long treaty history with the United States. That's the basis on which the Cherokee Nation that you may know or may learn about today exists in northeast Oklahoma. That treaty outlines what our reservation is. The United States then imposes the state of Oklahoma over the Cherokee Nation and other tribal lands. Keep in mind, the United States has promised our lands to us after removal forever and ever, literally from the treaty, that no state would be imposed on. That was a promise that I told you earlier about plenary authority of the Congress. Congress is authority just about anything it wants. It said, forget those promises. We're creating the state of Oklahoma. We're allotting the Cherokee's land, 7,000 acres in common, and they divided it up into individual Cherokees. There's about 3% of that land left that's in restricted status or trust status. That had special meaning. And before 2020, when the McGirt case came down, I would tell you that Cherokee Nation has jurisdiction over 7,000 square miles, but the different remaining 3% of land is really where we can assert authority like criminal authority and law enforcement and things of that nature, things of that nature. The Hoskin family allotment is in the middle of the pasture of Fayette County. There's not much that happens up there, except they cut hay here. But that would have been where I could tell you an example of you broke law, you broke Cherokee law. What McGirt said was that even though Congress can make lots of promises, it's got to really say it. It's got to say that it's destroying, in that case, the Creek Reservation. In this case, the five big tribes in Oklahoma. But the court said Congress didn't really say that, so the reservation still exists. That matters to you, but it matters to me. It matters to everybody that lives or comes through the reservation, whether they want to know it or not, whether they know it or not, it matters to them. Because it means these governments that existed before the United States that still possess the authority that governments possess, tempered and restrained as it is by the Congress, still matters. So when it comes to the Cherokee Nation reservation, you're subject to the laws to some extent of the Cherokee Nation. Now, that means something that's evolving as we move on and figure out what that means for the day-to-day lives of people. But we know it has implications for criminal law. I told you it had implications for taxation. And so that's why it matters to understand the role of the tribe. No matter where you are in the country, you really can't understand how the United States functions without understanding that. There's a tremendous economic impact today. We employ about 11,000 people. We contribute mightily to the state economy just through those activities. The ripple effect of all we do, tens, thousands of jobs. We support public education, higher education. We increased our spending on public education at a time when this state was cutting public education. We went the other direction. That's good for the schools in our area. What Cherokee kids do in school. We invest in infrastructure, water and sanitation, those are bring in ways seen and unseen, but in ways that make a positive difference in the state. The cultural fabric of the state can't be understood without understanding the tribal nation and our culture. So we have a history that's important and rich, and we survived against great odds. We do it against the backdrop of a really complex and interesting, in my view, set of legal principles that again go back to the Constitution. It goes back before the Constitution. First of all, we have inherent rights to govern ourselves, as any free people ought to be able to do, to self-identify. You layer upon that the Constitution, Commerce Clause, and layer upon that the supremacy of treaties. Now, one thing I want to share with you before we close and answer questions is that treaty that was imposed on the Cherokee people in 1835 that we later brought through subsequent ratification, in a sense, through other treaties. There's two things I want to tell you. One is in 1866, after the Civil War, we did something that as chief I try to talk more and more about, which is that we agreed not to enslave people. We enslaved African Americans in the United States. And we didn't talk about that as an Indian nation for a long time, except we resisted doing right by that treaty for about 150 years. But the treaty also says we give citizenship to free slaves and all of their descendants. We're doing it finally. That's because the treaty is the supreme law of the land. Two-way street, right? It's a two-way street. Treaties are free. The other part is look at that removal treaty. It's all this language about us ceding millions of acres and removing to a new home. And it's a source of injury and injustice for the Cherokee people. In that treaty, there's a sentence that says the Cherokee Nation shall have a right to a delegate in the House of Representatives when Congress shall make provision. So that treaty provision was untouched for almost 2 centuries. In 2019, we dusted it off and said, we are going to have a delegate. I appointed a delegate, our Councilman Danny Cowles, who's here. He's with the executive. I should have recognized him earlier. Councilman Cowles, before he took office, though, that we nominated a lady, Kim Peavy, Google Kim Peavy, who's a brilliant lady. We worked at the White House, Capitol Hill, private sector, advocating for Indian rights, and works for the Cherokee Nation. We said, hey, that provision is still the law of the land, the supreme law of the land. We've gone back and asked the Congress to cede her. So far, the Congress has not ceded her. A promise made out of being a promise kept, in my view. But the justice that I get out of it, I know my predecessor, John Ross, went to Washington, D.C. I know he said, you can't remove us. Trailer fears coming up. You can't impose that on us. And I guarantee you the federal officials looked across the table and said, Chief Ross, you don't understand it. That treaty is the law of the land. It's the supreme law of the land. Just look at the Constitution and you will abide by it. I promise you they told him that. Eventually they forcibly removed us, the tune of us losing a quarter of our population. I didn't go to Washington, D.C. and say, you don't understand. This treaty is the supreme law of the land. Look at Article 6. You will abide by it. I get to say that now. The government of the United States was more successful than I was. It's 3 years in, and they haven't complied with that one sentence. When they were enforcing the Treaty of New Echota, it didn't take them long to round a couple of stuff. It didn't take them long to remove it, did it? So we're pushing, but the point is, treaties are still living, breathing, alive documents. Tribal governments matter in your lives, but they matter in the whole scheme of understanding the federal government. If there's time for questions, I'll be glad to answer.
Let's go to questions. Thank you very much, Steve. Questions? I know I have people with questions.
Do you think the government wants Indians to have full rights, or do you think that they still want Indians to have them?
I think they decidedly, and even on paper, want Indians to have limited rights. And I should clarify that to say tribal nations to have limited rights. So before the United States was created on this continent, we had the full depth and breadth of sovereignty to govern our own affairs in the manner in which we chose. Now we know that's much more limited, right? We know that, for example, we can exercise criminal law adjudication, but get this, a non-Indian commits a crime against the Cherokee on our reservation, actual jurisdiction lies with the United States, not the Cherokee Nation. Why? The truth is because they didn't trust us to administer justice against non-Indians. I mean, it's one thing to put ourselves in jail for violating the law, but if you start to do that to a non-Indian, that's different. We went to Congress and the Violence Against Women Act, which people I don't know about, includes a provision that says, okay, if it's a non-Indian and they commit domestic violence, then you as a nation can protect that victim by holding the assailant accountable, even put a limit on how long you put the person in jail. So that's an example of a limitation. Here's another limitation. The town of Norman can impose a sales tax, right? Because they should, they want to raise revenue that way on the retail sales of stuff. The Cherokee Nation and the other nations tried to do that, and the court said, well, wait a minute, you can tax yourselves, that's fine. You would tax the non-Indian. Hold on, you can't do that. That's insane. Why would you be able to do that? That's an example of the contraction of the full depth and breadth of sovereignty. So I think they purposefully don't want tribes to exercise their full rights. If tribes exercise their full rights of sovereignty in this country, it would be a different country, and it would be a better country, but it would be a country that would look different from a legal standpoint in a way that we wouldn't quite recognize. But there's nothing wrong with thinking about what that world might be. Better world.
Okay,
Can you tell me about the McGurk case implications and what it means to your tribe?
Yeah, so the McGurk case, and I mentioned it a little bit before, in 2020, these cases often involve a criminal defendant who was a Native American, committed a crime in the Creek Nation, and was prosecuted by the state. Hundreds of thousands of people had been before that, pretty heinous crime. And the attorney said, wait a minute, he is a Native American, it just happened on the Creek Reservation in the United States, or the state said, wait a minute, it didn't happen on restricted land, it happened in the Creek territory that's historic. You have to dust off the map from 1906 to even really see Nice Drive and didn't count. The Supreme Court said, yeah, it does count. So what that means is that reservation and also the reservation of the Choctaw, the Cherokee, Chickasaw, the Seminole, which have this really substantially identical legal history, are all suddenly in existence. Now, we knew they never went away. The Supreme Court said they never went away. And now the federal one has to face the consequences of those reservations always existed. The case was about criminal law. Okay, and criminal law is unique in respect to the reasons I just mentioned in response to your question. Who we can prosecute, how long we can put them away varies. The United States government has jurisdiction in place, the state doesn't. So we're still trying to understand the implications. Some of them seem plain to people who understand Indian law as I do, income tax codes, for example. I'm not for this because I think Cherokee shouldn't bear their share of doing things like paying for roads, bridges, fire departments, and schools, and things like that. But the truth is, the law in this country is that if you live on a reservation and work on a reservation, and you're an Indian, the state can't reach into your pocket and impose a personal income tax. That's all really clear all the time. You go to the Navajo reservation, large reservation, there's not even a question. But this case is called Strobel. Strobel case, Oklahoma Supreme Court. Strobel was a Creek citizen, and she said, hey, you can't reach into my pocket because of the personal income tax. I'm Creek. I live on the Creek Reservation, I work on the Creek Reservation, therefore, the law that applies everywhere applies to me. The state's position is, nice try, but the Creek Reservation, for tax purposes, really just those few parts of the land that exist, kind of like the hospital lot in the middle of the pasture, that's what they're talking about. This case going to the Supreme Court, the Oklahoma Supreme Court probably is going to side with the state, we might get it. We've entered it in a weakest brief, so we agree with Indians on this one, naturally. But also not just naturally, because that's the law. I mean, so that's one of the implications. But what are those? I mean, we could take a lot of issues in response to your question, but think about the tax issue. If you're the state of Oklahoma and the largest tribe in the country, which has 450,000 citizens, about 200,000 live in Oklahoma, it's a lot of taxpayers, isn't it? And it's not an unfair statement to say, well, fine, but shouldn't everybody bear a burden here? And that's not an unfair statement. There's other ways to construct legal mechanisms, perhaps compacts to bear that burden, but it's not easy. It's tricky. There's a lot of political implications. I mean, how would you like to be the first chief to impose a personal income tax on the Cherokee citizen? I'm not signing up for that, by the way. Look, not a lot of politicians will admit they're politicians. I will. I would love to stay in office, so I'm not going to propose an income tax. But I also know that I like safe roads and bridges. law enforcement, schools. How do we figure that out? Those have real implications. This idea of exercising sovereignty is something tribal people have wanted a long time, tribal leaders. When you get it, it's serious business. Councilman Callison over there has had to make decisions about how we fund our government, and we've got constituents that want health care and save the Cherokee language and help people go to college, like the University of Oklahoma. But last year, we had to ask Councilman Callison and colleagues for $30 million to hire more marshals and prosecutors and courts and judges. Those are real implications that affect people. Those aren't theoretical anymore. Those are trying to decide what you do as a government. A whole lot of implications go beyond that. We are asserting hunting and fishing rights under our treaty over a large area of the state with a lot of people. What are those implications for the maintenance of fish and wildlife habitat? Hopefully good, but it's an obligation. You can talk about property taxes. You can talk about air and water. You can talk about civil regulation of businesses. We all benefit from some predictability, don't we, in terms of the business climate and attracting business and making sure everybody knows the rules of the game. But who sets those rules? The Cherokee Nation sets those rules. You could go a long time about this, but it is an important question that I don't have all the answers to, but we have to have it. Thank you.
I think we have one more question. Hi, I'm Kyla Comanche, and my question is, what is your biggest piece of advice for Native students that want to get involved in law and politics?
Well, it's a great question. Do it because we need more Native people to get involved in law and government and politics. We always have, but if you think about the tremendous opportunity we have today, where we're just now re-examining the treaty that we haven't examined for 200 years, that our ancestors suffered under, and your ancestors too. There's some obligation, I think, for those who can serve to it. And my advice is to get a good education. And I don't think I got a good education for so long as you're here. And I think that getting a good education first and foremost, and then going back to your tribe, there's lots of opportunities for you and lots of your peers that are natives to go lots of places. If you come back home, I can tell you, even a tribe as large as the Cherokee Nation, when we have a bigger pool of people, we still need more native in positions like judges and lawyers and all the whole depth and breadth of tribal government. So my other advice is to go back and get involved, and you can go anywhere in life, but your ancestors probably could have done a lot of things too. I think about that a lot. We could have disbanded the Cherokee people, but we didn't. So that whatever that draw was to stay together, that's what kept me back in the tribe, and I hope it keeps others back in the tribe. So my advice is to get involved in. We need young people involved in tribal politics, and those of us in office now aren't going to be around forever. Shouldn't be around forever, and we need new people to come in and new ideas to come in.
Anyone else? What would you like to see taught in school about the Cherokee Nation and the relationship between other tribal nations and the U.S. government?
I would like for young people coming out of school to know that tribes, including the Cherokee Nation, are sovereign, and that we're here before the United States, that it still exercises governmental authority. I'd like them to understand that tribes have a supremacy over states, and we just have to point to that Worcester versus Georgia case that I talked about. We can point to the dirt. It's not 100% above the states, and the states can pound sand because the Congress has a big role. If they knew those things, I think they'd have enough of a working knowledge to understand that tribes are relevant. The other thing is just history. I mean, there's a lot of people in this country that don't know that tribes are treated the way many tribes were. And it's not teaching that so we can hang our heads, be shamed. Understanding where we came from and understanding that those decisions had consequences. We're making thousands of decisions in this country every day that, for good or bad, will affect the future. And that's why we need to know the history.
Okay, thank you very much, Chief Ross.
Okay.
I hope you guys recognize while you're speaking exactly how much everything you talked about has to do with what we've been looking at for the last 7 weeks, 6 weeks, right? I mean, you know, from the fact that, how many of you read Killers of the Flower Moon? And so that's one of the books that, was an option for them to read for the civil rights chapter. And so just thinking about the Violence Against Women Act, if that had been in place in 1910, think about the difference in terms of enforcement, and the federal government actually responding to the needs of people at that time. That's one part of it. Some things that you should probably take from this is, number one, that your attendance quiz password is chief. Capital CHIEF, right? So that's your attendance quiz for today. And, we have the privilege walk on Friday. You're allowed to talk to you about that, you're allowed, fellows. I will be leading it. I'll be chatting with you through a bullhorn that you will love. And, or hopefully not shouting, really speaking. It's the idea through a bullhorn. But, we have an exam on Monday, right? It's online. You can come in here if you want to during the exam. You'll have an hour to take it once you open it. Certainly some things from Chief Hoskin, from what he had to say, that I would think about in terms of multiple choice questions include things like, I don't know, I like John Marshall's role in this, the plenary power of Congress, the 3 branches of government in the Cherokee Nation. Those are things that stand out to me a bit. So, you know, we'll see. But that's where we're with that. So unless you guys need anything else from me, I'm gonna let you out early today. I will see you on Friday. Boomer. Just a reminder, your essay questions are posted. There are 4 possible ones. 2 will show up randomly on your exam. You can prepare them up in advance and make A's.